guilty of the offense of murder, sentence you in accordance with your agreement to a term of 40 years in the institutional division of the Texas Department of Corrections. Speak up, I'm sorry.
Guilty.
Are you pleading guilty freely and voluntarily?
Yep.
And are you pleading guilty because you did what they charged you with? The indictment also alleges you were previously convicted of driving while intoxicated April 1st of 2004, and then October 26th of 2007, and then after that, December 4th of 2015. And are all of those prior convictions true?
Yes.
I have here on the tablet some documents that have your signature on them that the state's marked as exhibit number 1. Before you signed these, did you go over them with Judge Walker? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal? And it looks like the agreement is for a 10-year term in prison that would be probated for 5 years.
It's backwards. Should be 5.
Oh, 5 years probated for 10
Yes.
years. Okay, y'all are going to have to explain that one on a DWI 4th. I don't.
Wait, 10 years probated over 5 years.
That's not what's written here.
Okay,
What's written here is 5 years in prison probated for 10, and that's
transposed.
It may be.
so 10 years. So it'd be violating, so it'd be the whole 10 years of it.
Probation. Yes, ma'am.
5 years probation, 10 years in prison.
Right.
Correct.
That's our agreement.
Yes.
Okay, that makes sense. Got it. Everybody okay if I make that modification?
Absolutely.
Thank you.
Sir.
Thank you, sir.
Well, Mr. Parker for that, Your Honor.
Yeah, I think it's probably Alan's fault.
And do you have that attachment for this?
Judge, he wrote it out on the back of that.
Oh, okay, perfect. Thank you. All right. And so now it looks like the agreement that you have reached with the district attorney is for a 10-year term in prison, but that would be probated. You'd be on probation for 5 years. There would be a $500 fine, and you would be required to follow all of the rules and conditions of probation. Is that your understanding? And y'all wrote on count 1 only, but I think those prior counts are necessary for jurisdictional purposes, correct? I mean,
I think to play true to him, Your Honor.
yeah.
Yeah.
Okay, because there is only technically 1 count.
Right.
Okay, just making sure. Do you also understand, sir, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes, ma'am.
Is that right? One of them looks like I don't want to, so we've got 2 priors that were
Judge, I think the
misdemeanors.
confusion is the way we list the prior DWIs is more of a
Paragraphs, but the
It's
last
full, yeah.
paragraph, it looks like, is an actual
it is, Your Honor.
felony.
It is.
But it says relating to a driving while intoxicated second. Was it reduced? I don't want it to plead true to something that would actually enhance it up to a second.
Well,
Y'all know what I'm saying? That last one.
Judge, just for purposes of the record, we are pleading true to 2 priors.
2 priors.
For jurisdictional purposes only.
Okay.
And I'll tell you, the last one looks like a reduction, Your Honor.
All right. So what I'm going to do for the record is take those pleas of true on the first 2 enhancements, and then just waive the 3rd one so that there's no issues.
Thank you.
Perfect. All right. And so state tenders number 1,
No objection.
it's admitted. Is there any evidence that Mr. Ward is not competent?
None, Judge.
All right, sir, I'm going to find that you entered your plea of guilty and true freely and voluntarily. Sorry. Find that you're mentally competent and understand the nature and the consequences of your plea. Find sufficient evidence to find you guilty. However, I'm going to reset your case for sentencing so that the probation department can do a pre-sentence report. That'll give you more information about you and your case, and then we'll come back later for sentencing. On your way out of the courtroom today, you need to stop and talk to probation, and she's at that desk right over there. All right, we'll see you back at sentencing. Thank you.
Thank you, Your Honor.
Good morning, sir. Are you Andre Williams II?
Yes.
And this is cause number 24, DCCR 2286. I am going to take judicial notice of the court's file before we go forward. It looks like last year there was an evaluation for competency to stand trial, and Dr. Capon evaluated Mr. Williams and found that he was competent. Is there any other issues with regard to competency that we need to take care of today?
No, Your Honor. No, Your Honor.
All right, then will your client waive the formal reading of the indictment?
Yes, ma'am.
Sorry, it's my computer's something weird. All right, sir, in cause number 24, DCCR 2286, you're charged with the first-degree felony offense of murder, and that's from October 13th of 2024. And how do you plead to that charge?
Guilty.
Are you pleading guilty freely and voluntarily?
Yes.
And are you pleading guilty because you actually did what they charged you with? I have here on the tablet some documents that have your signature on them that the state has marked as exhibit number 1. Before you signed these, did you go over them with Mr. Vasquez? Do you fully understand them? And do you understand, if I follow the agreement that you've made with the district attorney, that you will be waiving or giving up any right to appeal?
Yes.
Do you also understand, if you're not a U.S. citizen, that a plea of guilty or no contest may result in your deportation, exclusion from admission to the country, or denial of naturalization under federal law?
Yes. State
tenders number 1.
No objection.
It's admitted. Is there any evidence other than what we've already gone over about any competency issues with Mr. Williams?
No, Your Honor.
All right, then, Mr. Williams, at this time, I'm going to find that you entered your plea of guilty freely and voluntarily. Find again you're mentally competent and understand the nature and the consequences of that plea. Find sufficient evidence to find you guilty, and at this time find you guilty of the offense of murder. Sentence you in accordance with your agreement to a term of 40 years in the institutional division of the Texas Department. You will receive credit on that sentence for any time that you've been in custody that the law gives you the right to receive. I'm handing you the trial court certification, right, that shows that this was an agreement that I followed, and so you have waived your right to appeal. I have also handed you a written admonishment regarding your ineligibility to possess a firearm or ammunition. Because of the judgment entered against you, you're ineligible under Texas law to possess a firearm or ammunition. Possession of a firearm or ammunition could lead to charges against you. Firearm is a legal term. You should read that written admonishment I provide you to see what devices qualify as a firearm. If you have questions about the laws that make you ineligible to possess a firearm or ammunition, or about how long that lasts, you can talk with Mr. Vasquez. And Mr. Vasquez, if you and Mr. Williams will please have a seat at council table. We have a victim impact statement. We'll go off the record for that. Have a seat over there, sir. Good morning. Are you Jasmine Jaquette?
Yes.
And Ms. Jaquette, this is your initial appearance in cause number 26, DCCR 0240. You're charged with the third-degree felony offense of deadly conduct discharging a firearm from March 4th of 2025. Since you've made bond in your case, have you had an opportunity to try to hire a lawyer?
Miss Bree, she gave me like the retainer, but I'm not working right now, so I've been trying to like, over my blues and stuff, so I haven't been able to give it to her, but we talked that she's gonna take it.
Okay, so are you working on trying to get a job?
Yes, ma'am.
All right, so what I'll do is reset your case for about 30 days to see if you can get Ms. Holmes hired. If you do get her hired or some other attorney, bring the reset notice that you get today to whoever that is, and they'll tell you what you need to do. If you're unable to hire Ms. Holmes or anyone before that next court date, then I'm ordering you to visit with at least 3 lawyers. You'll see that they all charge different amounts, they have different payment plans. Bring me back the names of the lawyers that you've actually talked to, so I know you're trying, and then we'll discuss your options.
Okay.
If you don't do that, then when you come back, you run the risk of me raising your bond for not following that court order, and you would go back to jail. Do you understand?
Yes, ma'am.
It's also important that between now and then, you need to try to find a job as well. Okay, and if you do find a job, bring me proof of that. Okay, step in front of the clerk.
Judge, given this defendant's recent,
Hang on just a second. Good morning, you're Carly Davis. Could everyone please hold it down? So Ms. Davis, you were late for court. I forfeited those bonds. I'll recall those forfeitures. It is extremely important that you are on time to court. Do you understand?
Yes, ma'am.
And so your cases are set for trial to begin with jury selection next week. Is everyone ready?
Your Honor, I think that my client has something she'd like to request of you.
Judge, before we get to that, given this defendant's recent violations of the drug patch,
So the drug patch, I have prescription. We've been
okay,
we've been doing that. We got the prescription. It's the same one. There's nothing different. Otherwise, I would absolutely agree with you. So You're not driving, correct? Right. So that was part of that agreement. And so what do you have to say?
With all due respect, I have, after our last time in front of you, I had signed a plea rejection, and it was Mr. Lynch had told me plea offer right before we came in here that morning. And you asked if I had signed a plea rejection on the tablet. She stated no, so we went in the hallway and signed it. That plea rejection was different than the one that she had offered me right as we were at the elevator. So I was a little confused, and it didn't click until it was over. I was still here waiting for my Uber, and I sent her a text, and I never heard anything back. And I've tried to call several times. She finally had texted me about a month later and said she had been out. She would call me the next day. And I can show records of where I've been trying to get a hold of her, and
So we're on our options that have iPhone records.
Well, yeah, it couldn't have been 30 days. I mean, there's not all that adds up because it's only been 30 days since your last court date. Here's the thing. I just need to know if we're going to trial or not. If you want to take a plea offer, then you guys can discuss that this morning and we can get it taken care of. But your case is set for trial next week. I'm not changing attorneys. I'm not setting it for anything. I will order the cases for trial tomorrow after my jail docket. And so you will know then what the trial order is for next week. But after today, there won't be any plea agreements accepted. Do you understand that? Yeah. So do y'all want to visit for a minute, or do you want to go forward with trial?
Probably.
Visit for a minute? Okay, I'll hold it. Y'all go visit. Thank you. Thanks, Sam.
And here's the pressure point every criminal defendant eventually faces: the trial deadline. Once a judge sets a firm trial schedule, the window for negotiating a plea can close fast. Judges do this to keep cases moving and prevent endless delays. Now the big question becomes, will the defense reach an agreement, or will they gamble everything in front of jury? If you were in this situation, would you take the plea or take your chances at trial? Tell us your thoughts below, and don't forget to subscribe for more real courtroom breakdowns.